Sometimes when a person can't make their own medical decisions, they need someone to step in and make decisions for them. In Ontario, we call this person a substitute decision maker. Often this is referred to as the SDM for short. It's just the acronym, faster to say. So in this video, I want to talk about who is the SDM. How do you even know? Often people use the phrase next of kin, but that doesn't really have the same legal meaning as a substitute decision maker, which is like a legally defined person under the law. So I want to tell you who that person is. And so I'm going to give you information about the law, and hopefully you can apply this video to your own circumstances if you're trying to figure out who your substitute decision maker would be, or whether you are the SDM for another person. So the Healthcare Consent Act is the main law in Ontario that tells us who our substitute decision maker is. And all of us have one. There is no piece of paper that is needed. You don't have to do anything, although you can, to appoint someone. We all by default have a substitute decision maker. And this makes logical sense because any of us could lose capacity at any time. Anyone could be in a tragic accident, have a medical emergency, and lose the ability to make their own medical decisions. So we all have one. That's the starting place. But who is it? The law creates an actual hierarchy. It's presented as a list, and I often use this hand gesture when I'm talking about it. It's a list in the law, but it goes from top to bottom in terms of how we determine which person is the substitute decision maker. So top of the list is guardian of the person. In order to become a guardian of the person in Ontario, one must actually apply to court, go through a whole court process, and there's a court order with the stamp from the judge and a plan that a guardian has to follow. So it's a big step, and pretty much always other people will have to be notified or legally served with paperwork that to know that this hearing is going on. So it's not something that is done kind of secretly and privately. There's laws in Ontario that say that certain people, like the person who is going to get the guardian, having to be served and notified basically. And if there's other immediate family members, generally they need to be told. So yeah, it's not like a fly-by-night operation, which sometimes I hear that concern. And it's almost always public because court records are generally in the public domain. There's also a registry. The Office of the Public Guardian and Trustee maintains a registry of guardians. So it is possible to call and actually ask, who is the guardian, and be told. So that's number one of the list, guardian. It's appointed by a court. Number two, if someone has made a power of attorney for personal care. And there are definitely issues that come up that we see all the time in our law firm about validity, what was the person capable when they wrote that, but putting those legal issues aside, at face value, if the power of attorney for personal care is witnessed properly, signed by somebody who was capable, that is second on the list. The person that they've appointed is the substitute decision maker. And if it's more than one person, then collectively they are the substitute decision makers. But that's only power of attorney for personal care. If somebody has made a power of attorney for property, too bad, they are not the SDM. Property doesn't come over in the healthcare side, they're separate domains. Third on the list is somebody who's actually been appointed by the Consent and Capacity Board. We did an earlier video on the Consent and Capacity Board. It's a tribunal in Ontario. There can be a hearing that takes place before this board about who is a substitute decision maker, and the board can decide and appoint somebody. It might be a contested hearing where more than one person wants to be SDM, or it might be uncontested, but this person still has to go through the motions of the hearing. So that's third on the list. Rare that anybody sits there, but it's good to know about it, especially for healthcare professionals who are trying to diligently figure out the SDM. So that's third. Next is spouse or partner. And a spouse or partner does not necessarily have to be married. If people have been living together for a year or more in a conjugal relationship, that can count. So the Healthcare Consent Act goes into more detail. But yes, it's not just married couples actually. And some people might be surprised to find out a boyfriend or girlfriend they've been living with is their substitute decision maker actually. After that, it's child or parent. When I say child, I mean 16 years of age or older. No one is asking a 5-year-old to decide for their parent, but if they're 16 or older, so child or parent. So for example, I'm in my 30s, I have parents in their 60s, and I have children who are minors. So for me, it would, if I went down this list and didn't have anybody else, it would be my parents. But somebody who's in their 50s might have parents who are alive and adult children in their 20s. Legally, they're all equally ranked, which can get very complicated because that might mean there's 4 or 5 different people who are all equally ranked substitute decision makers who have to make those decisions together. So another good reason sometimes to make a power of attorney for personal care is kind of outrank that and avoid that kind of confusion that would happen. I note if parents are divorced, things can get a little more complicated. It's possible one parent outranks the other and a parent with the right of access comes later. Children's Aid Society can also sometimes rank at this level depending on the unique circumstances of that case. Beyond that, it's siblings and then any other relative. And if there's nobody at all, very bottom of the list is the government. The Office of the Public Guardian and Trustee is the substitute decision maker of last resort. So we all have one, whether we know it or not. And that's it for this video. I hope you learned something new, and I'll see you in the next one.